Hi, my name is Mark Lloyd. I'm co-founder of Property Master Academy and I've been a property investor since 2005. In this short video, I want to talk to you about the rules, the regulations and the legislation of HMOs, houses of multiple occupancy. If you're interested in HMOs, then this is really important. You need to understand the rules and legislation. And so many people get confused about the difference between planning permission, licensing, Article 4, selective licensing, and so on. They get it all mixed up and they don't know whether you need a license, whether you need planning, etc. So, what do you need to do in order to buy a house, turn it into an HMO, and make sure that it's legally compliant? So first of all, what is an HMO? Well, the definition of an HMO is a building or a part of a building that is occupied by 3 or more people and 2 or more family groups who share basic facilities such as the kitchen, bathroom, etc. Now, student accommodation would be a typical example of an HMO. Where investors get confused, and rightly so, is when do you need a license and when do you need planning? Well, the answer is that it depends. So for the license, the national regulation is that you need a license when there are 5 or more unrelated people. So if you've just got 4 people, then you don't need a license. In most instances. However, this can be overridden by the local council because there is also selective licensing, planning, and something called Article 4, which all override the national regulations. Confused? Well, selective licensing applies to particular properties and is usually applied in areas where there is a lot of antisocial behaviour, but that can be applied to any property, not just HMOs. So for example, we purchased an HMO in Manchester which was subject to selective licensing because it had been identified by the council as a problem property. You need to apply for planning if you want to house more than 6 people in an HMO in most areas, unless there is an Article 4 direction in place. Article 4 is applied to an area by the council and is designed to limit the growth of HMOs. It's often applied where there are already a large number of HMOs and the council wants to control the growth of more HMOs because where there's an Article 4 direction, it means you also need to apply for planning before you can use the property as an HMO. Now that makes it very difficult to buy a property in an Article 4 area to use as an HMO unless it is already an HMO. Also bear in mind that Article 4 and planning are in addition to any licence that may be required. And to confuse matters further, planning is dealt with by the planning department and HMO licensing is dealt with by the HMO officer or environmental health department. So how do you know which applies in your area? Well, always check the council's website. I hope that makes things a little bit clearer for you. So how do you get a licence? Well, by the way, if you're finding this video useful, then please hit the like button and subscribe to our channel so you get notified of new videos that are posted each and every week. So how do you actually get that licence? Well, firstly, unless you need planning, you do not need to wait for a licence before you can start renting out the rooms. But you do need to apply as soon as the 5th room is rented out. And make sure your licence application is acknowledged by the council, otherwise your insurance could potentially be invalid if you do not. The licence cost varies from council to council, but expect to pay somewhere around £750 to £1,000, and this will last up to 5 years. To obtain the licence, the property needs to comply with the national regulations as amended by any local regulations and comply with fire regulations. All of these can be found online with your local council's website. So for example, the minimum room size for a bedroom is 6.5 square metres. However, some councils have made the requirement for bigger rooms. In addition to what I've just mentioned, the main other criteria is that you need to be an appropriate landlord, which basically means that as long as you don't have a criminal record, then the licence will be granted. It is very unusual for a licence not to be granted if you've complied with all the regulations. Now, all of this may sound a bit daunting. However, you can ask some HMO officers to come and view the property before you buy or before you start any works, and they are more than happy to give you advice. It may sound like there is a lot of regulation around HMOs, and you'd be 100% right. But the great thing about the rules and legislation is it keeps the cowboys away so that professional landlords like you can prosper. If you found this video useful, then please make sure you hit that like button, as that helps our YouTube algorithm. And also subscribe to our channel so you get notified each week as our videos are posted. Appearing on your screen shortly will be some further videos that will help you in your property business. Thanks for listening.